Trial is setting a new precedent for parents being held accountable for their child's actions. Joining us tonight to talk about all this is attorney Todd Flood. Todd, thank you for joining us as always. Let's start with
Thanks
that
for
jury
having me.
selection process, Todd. The pool, as we mentioned, it's about 300 jurors. What are prosecutors and the defense looking for as they look to narrow down the jury pool? And it seems it would be kind of difficult to find jurors who are not aware of this case at all.
No, everyone's going to be aware of the case. You want a fair and impartial trial. You want a fair and impartial juror. So, trying to peel back the layers of the onion of how someone thinks, whether or not they have any prejudice, bias, what they think about guns, the right to bear arms, prohibitions against guns, things of that sort. You want to first get rid of or make sure that all the jurors that couldn't sit there and say, hey, listen, I have a preconceived idea and I have a judgment already, you want them off the panel. That's why there's so many in this case. You have 400 people in there, and they only have 5 preempts. So this is going to be a long process, and the key here is getting a fair trial.
And Todd, what do you expect will be the defense strategy here? And do you think we could see the Oxford shooter take the stand in his parents' trials?
There's only 2 defenses in criminal law. One is, yes, I did it, but I have an excuse, the yet but defense. And the second defense is, no, you got the wrong guy. So the only defense that's going to be applicable here is the shooter's over there. It wasn't me. That has to be the defense. And getting in the mind of the shooter and saying he never communicated that stuff to me. I did not know he was in peril. All of those things, that's going to be the defense. And the cross-examination will be as such. The likelihood of the shooter testifying, if he's claiming the Fifth for his appeal because he says the judge made an error in his sentencing, which I don't think is going to get very far, but he has an absolute right to the Fifth Amendment all the way through appeal. So it's going to be very difficult, if not next to impossible, to compel him to testify unless you have some way to violate the Fifth Amendment.
And Todd, on the flip side of all this, what's going to be the strategy for prosecutor Karen McDonald and her team? And just how much of an uphill battle do they face in getting a conviction, given that this is the first of its kind case of parents of a shooter being charged in connection to a mass shooting?
Right, in connection to a mass shooting, not the first of its time of a parent being held accountable, but in a mass shooting, obviously. I think we've only seen the tip of the iceberg here as far as the evidence goes. I think there's quite a bit of evidence, but clearly, when you are a parent and it starts at the home and you give a child a gun who's in this mental crisis, knowing at one time he was paranoid, seeing, hearing voices and seeing things, and ultimately you give him a gun, and then you see in school on the day of the shooting, he draws that gun in a picture, someone dying, blood all over the place. Take 2 seconds. Hey, Ethan, step with me for a second. Let's go outside. Where's the gun? Do you have the gun? What's in your backpack? Just giving one iota of care to prevent this. Those parents had that opportunity and they saw it. But what did they want to do? They wanted to get out of that meeting. So I think the prosecution has a lot of ammunition. The facts of this case seem to be on all fours, but due process must go forth, right? We must put 12 people in a box and we let 12 people decide, and that's due process.
All right, Todd Flood, as always, appreciate your insight. Thank you for joining us today.
Thanks for having me.
Yeah.